Hello, everyone, and welcome back to the Universary. Our first case today is James Tyler Jr. versus Capital Home Improvement before Judge Meyer in Thurston County, Washington. This was fairly straightforward as one of the litigants didn't even show up to court. I really wish they had. It would have been interesting to hear more from both parties on this one, I think. Let me know what you think in the comments. Hope you enjoy.
All right, so we're back to number 4, which is James Tyler Jr. and Capital Home Improvement. And let me ask you this, Ms. Lorenzen, in your mediation session, did Mr. Tyler indicate that he wasn't going to participate in the trial?
No, he did not, sir. She told us to go out of where we were and go back to court.
Right.
And
you've been here the whole time, and he hasn't.
The whole time. Is there any way in the evidence that he submitted and we submitted that you can just make a judgment? Because I know if we get another contingency, then we have, more time being spent on this. And, we've been in business for 40 years. Never have we ever had a court case, a sue case, or sued somebody for not, I'm just at odd about this whole thing. I just want it to be done with.
I understand. And the mediator told you both to go back into the regular court session, right?
That's what I understood. That's why I came back.
All right. Yeah, we can go forward today and get a resolution entered. This is case number 37088, James E. Tyler Jr. versus Capital Home Improvement. Mr. Tyler is requesting a return of his deposit, which I believe was $1,366.15 for a contract that was entered into, apparently substantially entered into, on September 13th of 2022 for some replacement windows in a building or residence that he had.
It's actually his mother's home, and we did half of the windows in 2011 prior with such a good report. So they
can't. No, I read your document. Okay. I'm just making a record here.
Okay.
So Capital Home Improvement ordered the, let's back up. As part of this agreement, Mr. Tyler provided a cashier's check in the amount of $1,300 and some to Capital Home Improvement as a down payment or deposit on this project. Capital Home Improvement ordered the windows. The windows took a little longer to be prepared and delivered than was anticipated. They did arrive. Capital Home Improvement contacted Mr. Tyler to arrange a time to install the windows. Then there became some difficulty as to when that would occur and whether there was something happening with the Tyler family that was interfering with the project going forward. At some point, Mr. Tyler indicated he did not want to go forward with the project any further and wanted his deposit returned to him. Capital Home Improvement indicated that they had purchased these windows at his request under the contract and needed to be paid the final amounts of that contract or to install the windows. That installation never occurred. Mr. Tyler initiated this action requesting a refund of $1,930.15 for the deposit that he paid originally and for other time and expense that was involved in the case. Capital Home Improvement responded by filing a counterclaim. And was that for $1,366.15, Ms. Lorenzen?
I have to look
Your
at,
counterclaim?
I have to look at the exact amount. $1,866.15 for the fee I incurred getting ready to countersue. I paid somebody to write up all this. And in mediation, I offered to just give him the windows for his deposit. It's like, I don't want to go through all this. I mean, I wish we could just put the windows in. I don't understand. How does this happen after 40 years? I don't know. I feel like it's a total breach of contract. We ordered them in good faith since we don't.
Right, no, I understand, Ms. Lorenzen. You don't have to argue anymore.
Okay.
One of the things they tell lawyers when they're in court is to listen where the judge is going. If you're winning, keep your mouth shut.
Okay.
You don't want to convince the judge of anything else. So you're winning right now.
Okay.
Just need to know the number we're asking about. So 1866.15 is what you're asking, and that's composed of the balance due on the windows plus some money for what? Attorney's fees or what?
Attorney fee.
All right. So having made that record, it does appear to me that Mr. Tyler is in breach of his contract and that Capital Home Improvement is entitled to recover the amount of the balance due on the windows plus additional cost involved in preparing the response to this claim today. So I will award Capital Home Improvement a judgment in the amount of $1,866.15. And I'm going to sign an order to that effect. And you'll be able to get a copy of that from the court's website on Tuesday of next week. Now, this is being entered by default since Mr. Tyler did not come back from mediation and appear in the courtroom today. And on your counterclaim, principal amount is $1,866.15. I'm going to mark that the plaintiff was not present and the plaintiff's claim was dismissed. This is the 12th of January. All right, Ms. Lorenzen, I've entered a judgment in the amount of $1,866.15 in favor of Capital Home Improvement against James Tyler Jr. This is on your counterclaim. His initial plaintiff's claim is dismissed. He was not present for this hearing today, left after the failed mediation. Any questions?
No, thank you, Your Honor.
All right, and again, you can get a copy of this on Tuesday from the website.
Thank you.
That's it. That's all for today. Thank you, Ms. Lorenzen. You may
Bye-bye.
go.
All right, so what did you think of that first case? Now, the second one is before Judge Jeffrey Middleton. It's Dylan Devries versus Superior Trailer Maintenance, LLC. Mr. Devries contracted with this company to have a welding repair done on his trailer. It was supposed to hold the spare tire on, and it didn't work out. All right, I hope you enjoy.
First matter we're going to address this afternoon is matter of Dylan L. Devries versus Superior Trailer Maintenance, LLC, and Zach Davis. Mr. Devries, can you hear me?
Yes, I can, Judge.
This is a claim for $1,512.92 for a welding job for a trailer spare tire holder that plaintiff alleges was defective. The defendant, Zach Davis, was served by certified mail he signed for that mailing on November 30th. He has failed to appear. As such, he is subject to default in the amount you've requested. Mr. DeVries, would you raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes, I
All
will.
right, you submitted the claim under oath, but you also submitted some photographs and some other supportive material that gave me a better idea of exactly what happened. It appears that you had bad luck compounded by bad luck compounded by bad luck.
That is correct. Can I use that phrase? I love that because it has been an ordeal.
But this workmanship done by Superior Trailer Maintenance failed on the very first trip, causing the whole unit to fall off the back of your trailer. Is that correct?
Well, when you say the back, it was on the side. If you can see Exhibit 1, that's the tire properly mounted. So it was not on the back of the trailer. It's mounted on the side. Yes.
That fell off, causing additional other problems.
Correct.
Oh, yeah, yes, I am on. Not yet. Oh, thank you. Yeah, thanks. All right, small claims are not required to be on the record, but we are now on the record. I find by default that you're entitled to $1,512.92. Court costs are $63.50 for a total default judgment in the amount of $1,576.42. I'm not sure I would have awarded everything that you had asked for, but when the defendant doesn't show up, they lose by default. In a civil case, you don't have to appear. You're not in contempt if you don't appear, but if you don't appear, you lose. And so he owes this amount of money. Now, the judgment's a little bit confusing because it says you have 21 days to pay it or you can pursue collections. And then in another portion, it says if judgment was not paid within 30 days. But generally, the advice is if they don't pay within 21 days, you can pursue collections.
Okay.
151292. All right, this is a little of an issue here. Zach, you sued Superior Trailer Maintenance LLC and Zach Davis personally. Zach Davis signed for the certified mail, did not respond. And if he's a certified agent for Superior Trailer Maintenance LLC, judgment is good as to both. All right, you're still at the Crooked Lake Drive address?
Yeah, that's my Michigan address, sir. Yes.
All right, we will send you a copy of that judgment. The easy part is getting the judgment. The hard part is getting the money.
Yeah.
This is a limited liability corporation, so perhaps it'll be money that you can collect. All right, good luck, sir.
Okay, what is the instruction, Your Honor, for collecting?
Well, all right.
Or
All right,
go ahead.
Here's the instruction. If he doesn't pay within 28 days,
Okay.
21 days, you can request what's called a discovery hearing.
Okay.
And you can contact the clerks, and they will schedule a hearing where he will be subpoenaed to come to court to answer questions about your ability to collect on the debt.
Okay.
If he does not appear for that hearing, he could be found to be in contempt, and bond could be set in the amount of the debt. So once we start with the discovery hearing process, people have some more success collecting on the debt.
Discovery is how liquid or non-liquid he is or whatever, right?
Yes.
Okay. Okay.
Right.
I appreciate your time.
All right, thank you. That's why I'm here. Good luck, sir.
All right. Bye-bye.
All right, everyone. Our final case for today is back in front of Judge Meyer in Washington. This is Chao Liu versus United Airlines. And I just thought this was so charming. This man really did his best to advocate for himself. He explained his case, and I think the right result occurred. What do you think? Let me know in the comments. Hope you enjoy.
Chao Liu,
Yes, Your Honor, I'm here.
someone from United Airlines? I don't see. Okay. So Mr. Liu, did you, what's the status of this case? I saw United Airlines had filed some things, so I'm kind of surprised they're not here. Did you come to any sort of resolution or agreement with them?
Yes, Your Honor, not a resolution, but a lady, her name is Stacy. She had we had a couple of communications. She told me yesterday she would be here today, and
She would be or would not?
She will be
Okay.
appear. She told me in the email, but surprisingly, she's not. I'm not
All right,
sure.
we'll wait. We'll wait.
Okay.
Sometimes people have trouble. All right. We'll come back to that in a minute. Mr. Liu,
Yes, sir. I'm here.
hi there. So tell me again about your conversation with United Airlines.
Yeah, United Airlines most time keep no response to my request, but the last couple of days, a lady, Stacy, gave me a couple of email communications. She's pretty cooperative and not look like before. And she said, she sent me a letter. She said, "Oh, we want to settle with you. Give me
Wait a minute.
this."
Okay, slow down there. Say that again. She said
Yeah,
she wanted to settle with you?
Yeah, they want to settle with me. They send me a letter. I think at the court right now, they send the CC to you, and they said they give me a little amount, and then they give me some flight credit, and I
Did you
said,
accept that?
huh? I
Did you
don't.
accept that or take
No,
that?
I don't, because it's too much. It's not even close.
Okay.
And
Did you tell them that?
yeah, of course, we have a good we have a very good communication. Then I said, okay, I cannot accept this, and then they said, oh, send me some receipt. We will adjust the settlement. And then they request, the small receipt. I have so many receipts. They just give me some trouble. Then, but I still did it. I still sent them yesterday midnight, and
Give me
they
just a
got
minute.
everything.
Well, what do you want to have happen here today? I mean, they're not here. The default, I've read, there's a bunch of stuff in there. They filed some stuff here. I'm a little surprised they're not here. They filed some stuff here in the last week. And, but for whatever reason, they're not here now. And so, a default, if you're asking for that, could be entered in your favor. But if they come back and ask in a few minutes, I'm going to be dealing with a case where a default was entered and they're asking to lift that default. And they might come back and do that. And if they have a good reason to do that, then that might happen. But what do you want to have happen here today? Or it can be reset with reserving. But
yeah, no, I don't think they will. I'm pretty surprised they didn't show up, because Stacy told me she will show up and ask me to send the receipt. Probably, I think they should have a meeting. Maybe it's if there was a mediation, I think they should pay the amount, because they know the receipt is much bigger than the money I requested. And also, if I do mediation, the mediation should also in favor of me. If we go to court,
okay.
it's
So what do you want
further.
to have happen today? Do you want a default
I want
entered in
just
your favor?
All
right.
Yeah, thank you very much.
All right. And again, for the record, then I don't see anything where they contacted the court. There was service made. They're not here. And I don't know why or how. So a default will enter. But like I say, they may at some point make a motion to set this aside. And then we'll hear from them as to whether there's a good reason to set it aside or not.
They may think if they appear before you, they may pay more. I think I think.
But I'm not going to comment on that. They're not here.
Okay. That's what you are doing their business. They told something, they didn't do it.
Okay, so I really don't want to engage you in a discussion on this.
Okay, thank you.
And what's that? I know we're gonna have a lot of trials today. What number's out on the calendar? I'll come back to that in a minute. And Mr. Liu, I've entered the default. You're free to leave.
Oh, thank you. What's going on next? I should contact the office later, right?
Remember were you paying attention when I said people ask me what do I do next and I tell them I can't tell you?
Yeah, no, it's okay. It's okay. Don't waste
You're
your
on
time.
your own there.
Yeah, thank you. I'll contact the court. Thank you. Okay, bye.
We're gonna